We now have a quorum. I'm going to ask Senator Kirkpatrick if you'll open us up in a word of prayer.
Please bow with me. Dear Heavenly Father, thank you for another beautiful day in Georgia. We're getting towards the crazy time of the session, and you see all of it, and we're asking you for strength, calm, and fairness as we finish up this session. In your holy name, amen.
Thank you for that. All right, we have 7 bills on the agenda today. We have a hard stop for another hearing at 3:30, so we will do the best we can to get through these bills. We're going to start with House Bill 154. Representative Reeves, you can go there or the podium either way. And we are working off a substitute, LC 338766S. Is that correct?
Yes, that's right.
Let me get your mic on.
Check. Sounds like I'm on. Okay.
Here you are for now.
Ooh.
Go ahead.
Thank you, Mr. Chairman. This is House Bill 154. Most of you recall several years ago we had House Bill 159 that made it through the General Assembly that was a major overhaul of Georgia adoption law. And last year we came back, and typically when you do major work and rewrite a code section, there's oftentimes cleanup that comes a couple of years later that where there's some things that we didn't catch the first time, that we patched some things in. There was also a couple of scrivener's errors that were in the bill from a few years ago that we've caught now. And so the vast majority of this bill, it's 51 pages long, but understand that half of it is forms. Everything that's in the adoption code is also found in forms. And so anytime we change the code, it automatically requires the forms be changed. So the first half of this bill, first 25 pages, is what's relevant for discussion here. The only real significant policy change, the bill does a lot of clarifying based on our experience in adoption law over the last 2 years, and I'm happy to talk through those. The major policy change that we are looking at in here is moving the age that a petitioner is eligible to adopt from 25 to 21. And it's very important to understand a little bit of the context of this. First of all, in Tennessee, Florida, North Carolina, and South Carolina, that age is actually 18, and in Alabama, it's 19. We're coming in at 21. The reason why this policy is important, there are very, very, very few 21-year-olds out there that decide that they're ready to adopt a child. That may happen, and if that does happen and that person petitions in a court, then if any of you lawyers have ever done any adoptions, you know that it's one of the most highly scrutinized processes that happen in Superior Court, and the thoroughness of an adoption and the information that the judge gets before them is perhaps as thorough as anything as they make a decision on whether or not it's in the best interest for this person to adopt this child. And so it's very unlikely, very rare that a younger adult, 21, 22, would just, decide they're ready to adopt. If they did that, then they would be put through the process that the court puts one through, and ultimately the judge would determine whether or not it's in the best interest. Why is this important? Because there are situations that happen where there's an older sibling, and then and that older sibling has a younger sibling who is a minor, and something happens to both parents, and if there's nobody else in the family to step up in that situation, then that younger sibling goes into the custody of the state, whereas they would be able to be adopted by their older brother or sister, and then that person would then be their caretaker and whatnot. They would instead they go into the system. And so that is the scenario that this is attempting to cover. It doesn't happen very much, and sometimes it happens outside of the context of siblings, but those are all things that the court provides a lot of scrutiny for. There was a football player at Clemson several years ago, I forget his name, and he was able to adopt his younger brother because something happened to both of their parents. And that's a kind of a classic example of what we're looking to do. Right now, Georgia law wouldn't allow that to happen until the sibling was 25. And so that's the major policy shift in this. Everything else is pretty straightforward. I'm happy to answer any questions that any of you had. Did I do that in under 3 minutes?
You did,
Mr.
but
Chairman?
I had one question, so you'll be over 3 minutes now. What changes did you make in the bill with the substitute from what you passed in the House?
The only thing that's changed is the very last page. This was a defects bill that just didn't make it through the House. And this bill was a logical rider for it. And Director Rawlings is here, but this essentially would clarify in code that when if there's a disabled minor who is about to be of age and they're in foster care, they're under the custody of DFACS, and they are disabled in some way, then it permits the process to begin 6 months prior to their 18th birthday, so that the custody and guardianship of said minor person would be able to, you can initiate that process before they turn 18, so that once they turn 18, there's not a gap in them having a guardian. And these are obviously folks that need guardians and need help in that respect. And if there's any questions, then Director Rawlings can certainly. And there is one other change, I'm sorry. On page 25, this is just a clarification in the sentencing. There's some adoption fraud criminal laws that are found in the adoption code section. And on lines 117 through 119, this is just clarifying that restitution, if a person is frauded in an adoption and they've lost any money, that they would be entitled to restitution.
All right. Senator Kirkpatrick has a question.
Yeah, I was just interested in understanding line 607 to 614 on page 24.
Yes. So this is in the code section that deals with the criminal offenses that happen in the context of adoption, and 607 through 614 adds a very specific criminal offense that deals with when somebody has defrauded someone. I know that this sounds crazy, and it sounds like something that like you can't possibly be telling the truth here. Like nobody would do this. There are people out there that will fake being pregnant or facilitate someone being pregnant who's actually not pregnant and receive money under the auspice that there's going to be an adoption here, and it turns out they were never even pregnant. It was a scam. It was fraud. And this happens. It's happened in Georgia. It happens all across the country. And this is a code section that will specifically allow prosecution for those type offenses. And as you can imagine, that's the kind of thing that is just emotionally, for somebody to go through that process and think that they're going to be adopting a child and expend resources towards that, only to find out that it was a scam. It's a horrible thing, and it's something that we need the ability to be able to prosecute.
Here are questions for the author on the bill. All right, thank you very much. Nobody else has signed up to speak on the bill. What's the pleasure of the committee? We have a motion to pass by committee substitute by Senator Hatchett. We have a second by Senator Kirkpatrick. Any discussion? All those in favor of the motion, please raise your hand. Any opposed? Cowser, was that a yes as you're eating the pickle?
I was abstaining. I can't absorb a 49-page.
I was warned last week that I can't have anybody abstain. You have to vote yes or no on the bill when you're in your seat in the committee. All right, we have, so total yes is 1, 2, 3, 4, 5, 6, 7 yes, 1 no.
Thank you.
Thank you very much.
It's my shortest time ever in Senate Judiciary.
Mm-hmm. I mean, next time you'll get a unanimous vote when you come here.
The question is, where do you get the bandwidth? You just presented 2 bills of finance and you got 6. How many more you got?
Fake it till we make it.
Where do you come to time, man?
Hey, Representative Reeves, who's carrying this bill?
Senator Hatchett.
Senator Hatchett, thank you. He gets a lot of adoption business, at least, probably. Next bill we have on the agenda is House Bill 470, Representative Washburn. You're welcome to sit here or go to the podium either way. Okay, yes, sir. And I'm showing LC 500157.
That's correct, Mr.
All right,
Chairman.
the floor is yours.
Thank you. House Bill 470 is a very simple bill that deals with condominiums. It's very short, so I'm going to read it because this is productive to read it. Except for a unit that is an individual residential dwelling intended for single-family occupancy, nothing in this code section shall require plans for a unit when the boundaries of the unit are not designated by walls, floors, ceilings, or other physical structures, provided that the boundaries of the unit are depicted on a plat of survey prepared in accordance with subsection A of this code section. Nothing in this code section shall require a separate plat of survey for a subcondominium. Basically, I was asked to carry this bill by a law firm that represents a multi-purpose condominium developer because they had hit a snag on the closing of some construction lending because of the absence of floor plans in the non-residential condominiums. And so the bill just states that if there are no floors, ceilings, or walls in place, then those floor plans are not required for the non-residential uses. And so it's a very simple fix for a problem that has come up a time or two in closing some construction lending. And so, Mr. Chairman, I know you do have a long agenda. I'll be glad to entertain any questions anyone has.
So my understanding of this is a code section that talks about what must be filed of record when dealing with condominiums, so future purchasers will know what's coming as well as far as the record. Is that correct?
That is correct.
And this is dealing with properties that are not going to be residential use, but this is like a high-rise that's commercial as part of that. Is that correct?
That is correct.
But the residential units would still have to comply with this code section, otherwise it has to be recorded. Is that right?
That is correct, Mr. Chairman.
Okay. Anybody have any questions for the author of the bill? Now I feel like we're moving too quickly. Nobody else signed up to be heard on the bill.
Mr. Chairman, I might add the Georgia Association of Realtors are fully in favor of this change. They did not sign up to be heard, but Brad Mock is here with them.
Mr. Mock, do you want to say anything? All right. Well, you want to come up? You can come real fast. Okay. Come on up real quick.
I'm not as good as Representative Reeves is bouncing from committee to committee, and I missed the sheet, and I apologize. It is Representative Washburn did a great job walking it through. It is a fix to a problem that does not occur often, but when it does, it creates a hang in title insurance, and it stops significant development that a lot of people have plans for, both from a local standpoint and from a development standpoint, from happening. So we're very supportive of the bill and hope that you will be as well. Thank you for your time.
Are any questions for Mr. Mock? All right, thank you very much. Nobody else has signed up to be heard on the bill. What's the pleasure of the committee? We have a motion to pass by Senator Watson. Do we have a second? Second by Senator Kennedy. Any discussion? All those in favor of the motion, please raise your hand. It passed unanimously. I was about to give you the Cowser treatment, Tillery. Oh, no. Who's carrying the bill in the Senate?
Senator Brass.
Senator Brown. Okay, well.
Thank you, Mr.
All right.
Chairman, members of the committee.
Hey. It won't go anywhere anyway. Don't worry about it. I have too much sarcasm for a Monday afternoon. But next, we have House Bill 548. Representative Chairwoman Dempsey is here. Come on up. And I show working off LC 338627.
That is correct.
All right, the floor is yours.
Thank you so much. This should be pretty quick. This comes to us on behalf of the Division of Family and Children's Services, and this is a compliance bill. Actually, it's necessary for us to function well. It will allow the Administrative Office of the Courts to facilitate data sharing necessary, actually, to make sure that we take care of children who are perhaps the subject of dependency actions and actions to terminate parental rights. It is pretty straightforward. If there are any questions, I'll be glad to take them, but it allows them actually to work together.
And you referenced HIPAA in here. You tell us a little bit about that as well.
Well, yes, certainly it allows for that compliance as well. There are two actually sites that work together. So Georgia has 2 data sharing sites. One, Georgia Shines, which some of you may be familiar with, comes out of DFACS, and it's web-based, it's statewide. It's the Automated Child Welfare Information System. So certainly health information is on there as well. The court process is the other system that is there, and that secure system also has a central portal, and this will allow them to work so that court orders are upheld, and that it is in compliance with HIPAA and additional federal regulations, that the governing the disclosure of protected health information and federal funding is not put in jeopardy as well, which is very important.
All right. And you have Director Rawlings standing with you. Do you want to be heard on this bill as well, Director?
Yes, sir. Thank you for giving me a second. We have been sharing this information between DFACS and the courts for 15 years now. It's been wonderful. We just want to make sure we put the actual provision in the legislation so that it's clear that we can continue to do so. So thank you very much.
All right, fair enough. Any questions for the author or Director Rawlings? All right, now is the appropriate time. Wait, anybody else want to be heard on this bill? We have a motion from Senator Watson. Yes. Motion to pass to Senator Watson. Do we have a second? Second by Senator Kirkpatrick. Any discussion? All those in favor of the bill, please raise your hand. It passed unanimously. And who will be carrying this in the Senate?
Mr. Chairman, may I get back to you on that?
Sure.
I should know it, but I'm afraid I don't at this
That's
moment.
okay. All right, thank you.
Thank you.
Appreciate you. Is Representative Gunter or Representative Saints, Sains, excuse me, have they gotten back yet? Well, we will be at each just for a minute. I know Representative Gunter was still in House duty. We're going to see if we can reach Representative Sains. Representative Gunter, if you want to step up. And we have House Bill 371, and we have a substitute, LC 280308S. Is that what you have?
Actually, no, I don't have any. I'll have to dig a minute to get it.
We'll bring you one.
Let's see. Oh, thank you. All right, now I have it. Mr. Chairman, this is a bill that allows the courts to conduct hearings electronically or virtually. For the last 15 years, the courts have been developing Uniform Superior Court Rule 9.2. I remember back in the early 2000s, a magistrate judge in Lumpkin County started using video conference from the jail, which was just down the hill, to his office. It saved the officers the time of bringing the individual up to the court. It saved money for the county, And basically that little procedure there has spread to all the other courts, and this just recognizes that and has the courts to perform that under the rules that they've been developing over the years. We've made a couple of changes in it. In that line 29 where it says agreed upon by the accused, I forget what the previous language was, but it was kind of a catch-all phrase, and spoke with Jill Travis, and executive director of the Georgia Criminal Defense Lawyers, and that was language that they wanted in there. And also the Administrative Hearing Office wanted to change the House Bill 371 as it passed the House to take them out from under the Uniform Superior Court rules and apply it under their own rules. And so that's basically what the bill does. And I'll answer any questions.
I have a question on line 28. This is talking about a criminal trial where the accused's guilt or innocence is up for determination. It says unless otherwise authorized by court rule or agreed upon by the accused. That part, authorized by court rule, does that allow the Superior Court judges to have a rule that basically still allows for a criminal trial like that to be done electronically?
I think it's referring to Rule 9.2, and it wouldn't be where you would do it against the wishes of the accused. And that was the reason we added in the language on line 29, unless they agree to do it.
I guess the question on that is that or agreed upon by the accused. Should it be and agreed upon by the accused? Or am I missing something on that? And if Ms. Travis is here, if that was the part she worked on, I could ask her that. But
I wouldn't have a problem with changing it to and.
let me ask Ms. Travis if you'll address that question, if you will, for me, since you worked on that part.
If I don't fall over getting to the stage here. Good afternoon, members of the committee. Our 9.1 and 9.2 are the uniform rules that deal with video conferencing in the civil and criminal context. We've been assured that the criminal rules are not going to ever require a video trial by a criminal defendant. And so we were okay with leaving in court rules or agreed upon by the accused. Just good faith.
Okay.
I don't know that we would want to say and agreed upon by the accused. I kind of like the or because it gives us the option.
Okay, that's fair. All right, other questions for the author? First, we had Senator Kirkpatrick.
Yeah, I have a non-lawyer question for you. This has to do with, this doesn't comment on whether the proceedings are recorded in any way, if it's a video conference or a phone conference. Can you comment on that?
I'm sorry, can you repeat that one more time?
Video conferences or phone conferences recorded?
Yes, the 9.2 requires a court reporter to either record the entire thing, the visual part, and the words, or just the words. But I'm not sure about the detail on that, but it is recorded just like you would if you had a regular hearing with everybody there. It also has provisions in it about conference between the attorney and their client, being allowed to do that privately. Also allows them to have full visual of the evidence being produced, and also being able to observe the witness's demeanor as well as their testimony. Okay.
Senator Parent, did you have a question?
Thank you. I'm trying to remember, last year I think we had a bill dealing with video conferences. Can you just remind me what happened to that?
Senate Bill 344. I think Senator Mullis carried it out of the Senate. It came over to the House, and I think it was when all the stuff went on about COVID, and it didn't pass because of that.
So is this like the new version?
This is a different version, although it does the same thing. Instead of trying to spell out all the different circumstances that you would run into, that 9.2 already deals with. It just adopts 9.2 instead of trying to spell it all out.
Thank you. The bill number last year again was
344.
344. Thank you so much.
Senator Kennedy.
Thank you, Mr. Chairman. Representative, thanks for bringing the bill. Good to see you. And I know you've served as a judge, so you're very familiar with this. I really had two questions. One, on line 17, it says a judge of any class of court. So are we really applying this to any class of court? Will that include superior, state, magistrate, and civil? Some jurisdictions have civil courts.
Any of them that have hearings where they could do it remotely would apply, and they would have to have a rule that either they adopt 9.2 into their rules or they have their own rule that does it.
I think you preempted my next question, which was, do all of those classes of court, I know that state and superior court have the uniform superior court rules. Are there uniform magistrate court rules and uniform civil court rules as well?
Yes, sir, there are. I'm just not as familiar with them as I am with the superior court rules.
Yes, sir.
And how they've dealt with this already. But like I said, Jeff Lowe was a magistrate judge in Lumpkin County back in 2004 and 5, and he started doing video conferences for first appearance hearings way back then, and I know we've been developing rules since then.
I appreciate you bringing the bill. I think this is a great idea, and particularly with the backlog that's coming because of COVID-19. Just one more, Mr. Chairman, one more question. So looking on line 36, this provision talks about that for the proceedings that are conducted pursuant to this code section, provided that they will be deemed to have been conducted open court, provided that the judge or justice and the clerk of the court are participating in the proceeding. And I'm just wondering, since you have multiple judges in some jurisdictions and only one clerk, is that going to limit the applicability of this? And is that talking about the clerk of court?
No.
Such that would you want to consider maybe the clerk of court or an assistant clerk that could be present for purposes of complying with this?
In my experience as a judge, it never was a problem. If you had a deputy clerk come in to serve, they served as the clerk in that courtroom. So I don't know that you'd really need to put anything else in there.
Okay, so you think a deputy clerk appearing would suffice for even though the text of the language says clerk of court?
Right. My reading of it is it's more of a reference to the clerk's office.
Okay. Okay. Thank you. Thanks, Mr. Chairman.
Senator Tillery.
Thank you, Mr. Chairman. Thank you, Representative. I have a quick question on lines 19 and 20. It talks about, I get it, the classes of courts, they can do this, and then administrative law judges may do it pursuant to Chapter 13, Title 50 of the Administrative Procedures Act. Is there a reason why we want to just name those two courts? Should we not just say all administrative courts can do it pursuant to the Administrative Procedures Act?
Honestly, I'm not that familiar with that side of it, so
right. I just don't want to
limit
limit
it. There are other administrative hearings to be conducted out there. I will say that in, I think it's my other bill that I have here, there was another class of court that would be included in that. Let me see.
I guess that was my thought, and thought maybe by striking that language we could
in my next bill
make it wider.
In Department of Community Health, who
right.
conducts those kind of hearings.
Pursuant to the Administrative Procedures Act,
right.
too. I may have an amendment at the right time, Mr. Chairman.
Okay. Senator Cowser.
Thank you. I'm not giving you freshman razzing here, Judge, but I'm puzzled by Section 1 on lines 9, 10, and 11. We're not accustomed to having legislative findings on our bills until the last couple of years. I'm seeing them pop up. Kind of appellate interpretations of our statutes don't rely on any legislative history. But you're saying that this is already authorized and this is merely codifying. Well, why do you need a law if it's already permitted? I'm not being funny about that. I mean, you're saying here that these provisions are authorized under existing rule and laws.
Yes, sir.
So why do another law to something that's already done?
Well, partly to answer your question is there was a lot of assistance or influence with the appellate courts in drafting this. And this is definitely a recognition of something that is already going on. So it's I guess putting the stamp of approval by the state of Georgia on these type of hearings.
May I continue? Does this require consent of either party, or the judge can just say, I'm not going to have a hearing in open court for you. I may be in my home, you can be in jail or in your lawyer's office or whatever. I mean, or do both parties to such a hearing have to agree to do it by video or phone?
I think it's an implied agreement. Most of the time it's not objected to, but if anybody were to object to it, the judge would most likely, I would have conducted a hearing to find out why and listen to the reason why. And really it would only affect like first appearance hearings or some other short hearing where you're just making an appearance with the individual. And it would be in the judge's discretion if somebody did object to either grant their request or to deny it and go ahead and go forward with a hearing, mainly out of safety and cost for a short hearing that really doesn't amount to much jeopardy to the defendant.
But my problem here is this doesn't say just for those type of hearings,
Right.
and it doesn't say, I mean, it's total discretion of the judge, so there'd be no way to appeal it if a judge denied your request to be live, assuming the court rules permitted that.
Right.
Okay. And my final thing is, I just wonder if you've contemplated this, is that, doing a trial practice, there's so many times where, I don't know whether it's body language or nuance or whatever, but being in the presence of the witness and having them be observed by the judge, and the public being allowed to participate, it seems to me you get so much more. Like I've had trials or things that come up with somebody has a new witness and I ask, can I have a minute to interview them in the hallway or whatever? That's gone here, and documents presenting them to a witness for your hearing, it's just impossible almost to do that, or it is for me if I'm in my office trying to show a document to a witness that's in another office and the judge is not even in the courtroom. Have you worried about some of the technical problems you might have? Because you're mentioning testimony. These are testimonial type hearings, evidentiary hearings.
Sir. We need to go back and actually look at 9.2. It deals with a lot of these problems, and like I said, it's been developing over the last 15 years. So a lot of what you're asking about is dealt with 9.2. The other part of this is when there's going to be a hearing conducted this way. I know in my circuit we have a standing order that deals with part of it, but we also have specific orders that are already written out for this type of hearing, and it's tailored to each case. So if you understand what I'm saying,
right.
The court deals with it that way.
Okay, thank you.
Just one follow-up question on that. So this bill would only apply, though, to hearings. It would not apply to any sort of trial, is that right?
Only if the accused would wish to have it done that way. And the court agrees. That it's going to take everybody's agreement if you're going to do a trial that way.
Even in a civil matter, unless I'm missing it, it would still only apply to hearings in civil matters, correct?
Correct.
Okay. I had a question asked about the effective date. Is there any reason you wanted it July 1st instead of the signature of the governor?
No, sir. In fact, I think upon the signature of the governor probably would be better because it would help out with this COVID crisis to go ahead and get it going.
Okay. Senator Kennedy.
Thanks, Mr. Chairman. Judge, just one more question. In the vetting of the bill on the House side, was there any discussion of possibly sunsetting this bill?
No, sir.
Okay.
Any other questions for the author?
And in addition to answer the question is, this is something, as Senator Cowsett pointed out, it's already going on. And it's going to continue to go on, whether this bill passes or not. This is a recognition of what the courts are already doing.
Thank you.
All right. Thank you, Representative. We have Deborah Nesbitt with ACCG signed up to speak. She waves, but they support. All right. Any other questions from the committee? All right. Now would be the appropriate time for a motion. Any motions from the committee? All right. The bill fails for lack of motion.
All right.
If you'll stay where you are and present to us House Bill 553.
All right, this is a bill where the State Administrative Hearings Office allows them to do video conferences for their hearings. The first part of it sets that out.
Before you get going, make sure we're looking at substitute. I have LC 338758S. Is that right?
That's correct.
Okay, thank you. Sorry to interrupt.
Section 2 does two things in it. Paragraphs 4, 5, and 6 have to do with setting out an e-filing system for the state administrative hearing offices. I checked with them. They have that in place. They don't have to buy any software or do anything like the Superior Courts did in the e-filing bill that came through a few years ago. The other part of it under D1 is just to add in the Department of Community Health in doing their own hearings. It includes them in. And that's all that bill does.
All right. Any questions for the author on House Bill 553? All right. Thank you. There's no one that signed up to speak on this bill. What's the pleasure of the committee? Do we have a motion on House Bill 553? We have a motion to pass by Senator Hatchett. Do we have a second? Second by Senator Kennedy. Any discussion? All those in favor of the bill, please raise your hand. All opposed? Did you vote yes or no, Senator Tillery? Vote yes. Okay, passed unanimously. Who's going to carry this one in the Senate?
Tell you the truth, I haven't thought much about it.
You want to report back to us tomorrow?
Yes, I
Okay.
will.
Thank you. I appreciate you.
Thank you.
All right, moving on to Senate Bill 258. Representative Saines, if you want to step up. And we are working off of LC 28025S. Is that what you have?
Yes, Mr. Chairman.
256S, yeah. All right, the floor is yours.
Thank you. This is merely a modification to the sexual battery and the aggravated sexual battery statute to intake the decision in State v. Williams 2020 that noted that the prosecution must with current law, the prosecution is not exempt from showing a lack of consent for underage like they would be in child molestation because the statute currently does not provide such exemption. Apparently, this has been assumed generally in other this hasn't been an issue because it's been assumed, but as the court grows more contextual, this was something the prosecuting attorney counsel brought to me as something we wouldn't want happening. I won't go into unless the committee would want to know the details of State v. Williams, but it was involved a 4-year-old girl and her step-grandfather, and it's pretty egregious. So this rectifies any possible situation for that, and it did pass the House unanimously on the floor with a bipartisan support.
All right, thank you. I've read the case, and as you said, the 4-year-old child's involved, and that conviction was upheld, but it was mentioned in the case, the idea that you do have to, in certain circumstances, lack of consent is relevant, especially if it's a non-sexual contact. And you put in your bill under the age of 16 when the conduct is for the purpose of sexual arousal. And I think that gets to the heart of what that case was saying. We have any questions from the committee? Hold on. No questions from the committee. We do have someone signed up to speak. Mr. Cranford, the district attorney from the Coweta Circuit, is here.
You mind if I just speak here? Mr. Chairman, thanks for having me. I'm Herb Cranford, as you said, DA of the Coweta Circuit. I'm here on behalf of the DA's Association. We are in favor of addressing the issue that came about in the Williams case. I think this change helps, but it does maybe create an issue, unintended, I think, but I just want to bring it to the committee's attention. I've had cases in my circuit that deal with adults who, for no apparent sexual purpose, do awful things to the sexual organs of children. In cases I've had, it's been for disciplinary reasons, and I think this would create an issue for those type of cases. I do think it addresses the issue that Williams presented, though. But now, with this more specific language requiring, for the purpose of sexual arousal and part of the alleged offender or alleged victim, that doesn't, if I'm reading this correctly, prohibit just injuring a child in that way for a non-sexual purpose.
And in reading that case, it seems to point out, though, there are certain types of contact, such as what a doctor would do to a child or checking the temperature of a child, that is not sexual in nature. And those type of cases, you're saying you'd have to show there was at least lack of consent by the victim. How else could you do this otherwise? How else would you deal with those type of cases?
I think, and as I understand, that's why the sexual arousal element was added. I don't know if there could be a medical exception or something of that nature. Like I said, I just wanted to make sure the committee was aware of maybe an unintended consequence of the current language we have. As a practical matter, as a person who was an ADA for years before becoming DA, reviewing a case, we're always case-by-case review trying to decide, is this a person who had any actual criminal intent to do the thing that the law prohibits? So if I'm reviewing a case and it's a medical professional or something, I can't imagine bringing charges unless I was convinced I could prove beyond a reasonable doubt that intention. And I suppose there are, like any case, it could get difficult factually. I mean, we're all aware of the gymnastics doctor that, under the guise of medical care, was doing inappropriate things. So, cases by their nature can get factually, intensive. But I would be confident relying on the discretion of DAs and prosecutors in deciding whether an accused had the requisite intent. And so I think our recommendation initially in discussing this was essentially this language without the for purposes of sexual arousal. And one other thing to bring to y'all's attention, I don't believe there's a so-called Romeo and Juliet provision of this statute, and that might be something worth thinking about, because previously it just required the state proving a lack of consent. And now we're saying, if you're under 16 and it's for a sexual purpose, you can't consent. And, the reason those Romeo and Juliet provisions were added to all the other sexual offenses were, this policymakers decided that should be a misdemeanor offense when two people are within 4 years of age and between 14 and 18.
You have a question from Senator Hatchett.
Thank you, Mr. Chairman. and I don't practice this area of law, and I guess my question is, right now under the current code section, when you spoke about the contact for disciplinary reasons, is there a provision under the current code section as written for y'all to prosecute those individuals if it's done inappropriately?
That's a good question. I think potentially you could do it under cruelty to children, depending on, presumably if somebody's doing something that messed up to a child, there's going to be the heightened level of, mental or physical pain required by cruelty to children. But theoretically, there could be a crime that not done for purposes of sexual arousal that for various independent, individual factual reasons doesn't meet the, I think it's cruel and excessive mental or physical pain. I suppose then it could be, a simple battery or something, but that's, a misdemeanor.
Mr. Chairman, if I can follow up with that. So just to understand, this provision that would be added, do you think that it would take away or belittle those areas of the code section and prevent further prosecution for those types of crimes just because of the line 13 of sexual arousal?
Do you mean take away from the use of cruelty to children, for example?
Yeah.
Off the top of my head, I don't think it would create any kind of lenity issue or anything like that. I think if we're dealing with a factual situation that does not involve, sexual arousal, but did, involve cruel, excessive mental or physical pain to a child, then we could still pursue it under cruelty to children. Yeah, I'm just imagining a scenario maybe where, for whatever reason, the state's not able to prove beyond a reasonable doubt, excessive physical pain, but still somebody did something to the genitals of a child, not for a sexual purpose, but that everybody would agree that should be prohibited.
I understand.
Yeah.
Senator Kennedy.
Thank you, Mr. Chairman. I think I've got maybe the same question that Senator Hatchett has, and I'm just not understanding. So, do you think the phraseology for the purpose of sexual arousal is too limiting and would somehow restrict your ability to prosecute cases that otherwise you would want to prosecute, or is it the reverse? I'm not sure.
It's the former.
Okay.
We're adding the element of for sexual arousal will limit our ability to pursue cases that we can currently pursue.
Okay, got it. And one more, Mr. Chairman. And I don't know if you or the sponsor of the bill may want to answer this, but I'm trying to learn because I don't practice in this area either. What's the concern with the case that was referenced? Was there something about that case that the current status of the law rendered that you couldn't prosecute or as fully as one could? And I'm thankful that y'all haven't gotten into the facts of that case. That's not what I'm wanting to hear. I'm just wondering, is there some loophole that we're closing that was a problem in that case?
So for the aggravated sexual battery statute under subsection B, and we're talking about 16.622.2. It's an offense when a person intentionally penetrates with a foreign object, a sexual organ, without the consent of that person. And there's normally the law contemplates that anyone under the age of 16 cannot consent to a sexual act. But I think that's why the language was developed the way it was, to say if a person is doing that kind of thing for a sexual purpose to a child under 16, then there can be no consent. And so that Williams case came down where the law required the state to prove a lack of consent, but the judge also charged that a person under 16 can't consent. And
Okay.
The Court of Appeals overturned it, and for procedural reasons, the Supreme Court upheld the conviction. But
Got it. Thank you for that explanation. Thanks, Mr. Chairman.
Any other questions from members of the committee? Anything else you wanted to add, Representative?
Yeah, I just wanted to note that in terms of not having a Romeo and Juliet provision, the rationale to have one for statutory rape would be because the offender might be unknowingly committing an act that, other than in the law, would be agreeable. In the aggravated sexual assault and sexual assault, there's a forceful penetration. So it would be it wouldn't. Sorry. Battery, I apologize, sexual battery and aggravated sexual battery, it would be inappropriate to utilize a provision when there is force in the situation, which is why that the bill does not include that in this. And there was the bill did start out wider than it is now, and there was concerns because we are taking away an element of proving the crime that we needed to be cognizant of that and be very scoped, and we scoped it as State v. Williams would intend on why that provision would be allowable.
All right. Any other questions for the author of the bill? Thank you very much. There's nobody else has signed up to speak on the bill. What's the pleasure of the committee? We have a motion to pass by Senator Tillery. Do we have a second? Second by Senator Jones. Any discussion? All those in favor of the motion, please raise your hand. It passed unanimously.
Thank you.
Thank you very much. And you can sit tight and move on.
Do you need to know the Senate sponsor, Mr. Chairman?
Yes, thank you for reminding me again.
It should be Senator McNeil's first bill on the floor.
That's the easy thing to take on for your first bill, I'm sure. All right, the next bill we have on the agenda, well, you noticed it for a hearing only just so we could go through it. It's a little bit longer bill. House Bill 194. And we are working off of a substitute LC 480416S. And I'll turn it back over to you.
Thank you, Mr. Chairman. And for the members of committee who might have reviewed this bill prior to today and were working off a different substitute, just to note that there wasn't a bait and switch. It was procedural changes that Department of Community Supervision asked for because the House went into each different crime to input the provision. But it is a long bill. It is most of it is the use of formatting within each section. So there are about 5 major points. If it's at the pleasure of the committee, I'll quickly run over them. The page 2, where section 2 starts, that is the use of lifetime probation. It shows that in the example of aggravated assault. That is paralleled and continues until about line 8, where the sexual offenses are listed. So if you look at the first one, you can see what it's done for each element of each crime, which is after the second adjudicated felony level sexual crime, that the lifetime probation then is triggered. That is a safeguard we put in place. It originally started with one felony level sexual offense, but to scope it in to really try to target the dangerous sexual predators. We know through SORB leveling that the highest likelihood of being a level 3 offender classification is at about 92% of those reoccurring offenders are going to be then leveled. And we don't know that at the time of that first court hearing, but that is the likelihood. So that's why we utilize those 14 frameworks. Again, that list is on page 8 of the full items. Though it's lifetime probation to set a state standard, there is on page 19 the provision that the state must go before the judge after 10 years of probation. As long as that offender has met all the conditions of probation, the judge is then able to take off that lifetime offense if appropriate. This is really because of State v. Williams instituting that Georgia sheriffs could no longer do a GPS monitoring for a sex offender as a condition of them on the registry. This is the state showing some restraint, knowing that we don't have the most valuable SORB
SORB information possible, which comes on while the offender is in custody and in probation, to know if they truly are a level 3 dangerous sexual predator. So we're holding that back and waiting until year 10 of probation to then allow the judicial discretion of if this is appropriate or not. Most of the other items, like on starting on page 14, there's an investigator that switches from GBI to SORB. You'll notice throughout the bill that SORB had requested their name be changed from the Sexual Offender Registration Review Board to the Sexual Offender Risk Review Board, and that is about every major highlight of the bill. I apologize. There is one where you see the GBI did request a change to on page lines 22 to 25 in terms of prosecuting for sexual exploitation of children, how we define having a picture. Not the same copy of a picture, but different pictures. Those would be separate crimes charged under this code section. That's all, Mr. Chairman.
So a big purpose of you having these sexual felonies and the mandatory life sentence is a big part of that the ability to still monitor these individuals for the rest of their lives. Is that your main purpose of that?
It's to rectify the public policy issue. We through State v. Williams, about 400 offenders, and that's a general number, went from being monitored where a sheriff had decided after their probation that they still posed a risk to the public, so they decided to utilize what we know is a very strong deterrent mechanism, which is the GPS tool, and have them on there. Because that's a violation of a Fourth Amendment right if that individual is not serving a sentence, the court deemed that inappropriate. We can't do anything to those individuals to what some would say rectify the situation if they are a risk to the public. However, going forward, because we know this change in landscape, this would have the state show restraint for a very narrow portion of that population that would, in the future be included in a decision like that, to hold back on not utilizing that tool and give that lifetime probation, which in reality is a 10-year stepping stone to review if that's an appropriate utilization. If SORB, and it can go both ways. SORB finds the most valuable data of risk or non-risk the first 10 years. So there's plenty of instances where SORB's original level 1, 2, or 3 is moved down because of the offender doing classes and just following the law. So by instituting that 10-year period and giving the discretion at that point, it's very likely that an offender that doesn't show a risk has an increased chance of getting off that probation at that time.
And why is this something that we're saying a judge shall do versus letting the judge have discretion to do this in certain cases?
Upon the original second sentence, the policy feeling there is to create a state standard. Again, we are not capturing all the individuals that would be on, that a sheriff would have decided that they're at risk. So we are trying to use a very data-driven approach of why this offender could impose a future risk, which again, 92% of offenders that SORB has in their database now, those that, if we look at those that have 2 of these crimes listed here, they're about 92% likely of being a dangerous sexual predator. So for those instances, we want the state to know anywhere they're at that this is a minimum standard that we're utilizing. And again, holding back the judicial discretion to where the judge has the information that's necessary to determine that true risk.
All right. Any questions for the author, Senator Kirkpatrick?
Yeah. I just want to understand the timing. So currently, the judge wouldn't have the SORB recommendation necessarily, the leveling information when imposing the sentence, right?
Currently, they're likely to not have it, but most importantly, they're not going to have a lot of the valuable information that SORB obtains throughout the time of that offender being in custody to give a more a leveling with more fidelity for that offender, both at a reduced risk or at an increased risk to the public based on their behavior.
Any other questions for the author? All right, thank you. There's two other people signed up to speak on this bill. First, we have Jill Travis with Georgia Association of Criminal Defense Lawyers. Good afternoon.
Good afternoon again, members of the committee. My name is Jill Travis. I'm the Executive Director and Policy Advocate for the Georgia Association of Criminal Defense Lawyers. We have a few very simple requests. I'm going to shout out some line numbers: 45, 47, 63, 65, 85, 87, 96, 98, 106, 108, 115, 118, 128, 130, 139, 141, 153, 154, 163, 165, 173, 175, 218, and 220. If you look at all those lines, you'll see the word shall. The proper word should be may. In fact, Senator Kirkpatrick probably knows why. She probably could recite verbatim. The Senate has already considered this issue. In 2019, the Senate had a study committee on the protections from sexual predators. It was Senate Resolution 371, championed mostly by Greg Kirk, who was a member of your committee. Reading the final conclusions, the study committee recommends legislative action to give judges discretion to include lifetime GPS ankle monitoring in a sexual offender's actual sentence by having the leveling information from the SORB available at the time of sentencing. The other senators that served on the committee were John Elbers, Randy Robertson, and it was chaired by Renee Unterman. The study committee met in the fall of 2019 and heard from the Prosecuting Attorney's Council, the GBI, the Department of Corrections, the Department of Community Service Supervision, the Sexual Offender Risk Registration Review Board, and GACTL members. Unfortunately, House Bill 194 does not reflect the recommendation of the Senate Study Committee in any respect, but it removes the judge's original discretion to decide if in this case, this person that stands before this judge should receive a life sentence and should have lifetime monitoring. And it fails to account for the evaluative process that SORB is uniquely able to provide. What will a life sentence mean? It will mean the person is not eligible for parole consideration until he serves 30 years, and he'll have to wear an ankle monitor for the rest of his life. I realize that there is a provision in here that he may come off early, but this bill, I say it's like using an airplane crop duster rather than one of those little hand-turned things that when you put out fertilizer. It spreads this whole life sentence on all of these people without knowing why. Let's talk about some of the crimes. Statutory rape. It is not unheard of a 19-year-old to be dating a 15-year-old. That's a high school senior and a freshman. Enticing a child for indecent purposes can be accomplished via a sting operation with a law enforcement officer posing as a participant when there's no actual touching involved. Improper sexual conduct. That could be a 22-year-old substitute teacher being romantically involved with a 17-year-old student who's not actually the student in their classroom. Computer pornography. It's when a person uses a computer with identifying child information for the purpose of offering sexual conduct with a child. It's a viewing crime, not a doing crime. This bill removes all the discretion. It just looks at the name of the crime. It doesn't look at the person or their actions. The Senate knows better than that. This bill expands the number of people who will receive life sentences and increases the length of Department of Community Supervision which will increase the DCS caseload and will require more resources. That was something that was brought to the attention of the study committee. So there's a fairly easy fix. I know I gave those line numbers out pretty quickly, and I can obviously provide that information to you. I want to also bring to your attention something that was added kind of last minute. So you understand the purpose of this bill. The purpose of the bill is to deal with the Parks decision, which was that somebody did not receive a life sentence and therefore could not be monitored for life because of constitutional concerns. This bill was not about changing the law on how to prosecute child pornography cases. On lines 222 to 225, that was a last minute change that was added in the House committee. It doesn't account for the fact that child pornography and downloading of images, I think Brendan Spar is testifying after me, and he has a better sense of technology than I do. But I do know that, sometimes you click on something and then you get more than you thought you were going to get. Well, this would allow prosecution for all that you got, even though you weren't intending to get all of it. And that's a problem. The language in this, the way it's written, we think is problematic, and it doesn't go to the spirit of this bill. I'm happy to stand for any questions.
Any questions for Ms. Travis? Thank you very much. We have one other person signed up to speak. Brendan Spar, Executive Director of Restore Georgia. Good afternoon.
Good afternoon. Thank you, Mr. Chairman and members of the committee, for allowing me to speak to you today about House Bill 194. My name is Brendan Spar. I serve as the Executive Director for Restore Georgia, which is a nonprofit organization made up of all volunteers who are a collective voice for people impacted by sexual offense laws in Georgia. Mr. Chairman, last week in the House Judiciary Committee, you remarked about how thorough that committee was, and you wanted to bring that back to this committee for the equal thoroughness. So in doing your diligence on this bill...
I was being sarcastic, of course, right?
Well, no. You were thorough, and this committee is thorough. So in being thorough, consider the reason this exists. As Ms. Travis said, it's to protect Georgia from sexually dangerous predators. That's the root of this bill here. The Sexual Offender Registration Review Board classifies the dangerous predators by looking at several factors, none of which are the crime that was actually committed. They're looking at things like the age when they were committed the crime and the victim, the age of the victim, some other things like that. They're not looking at the actual letter of the crime. But what this bill would do is it lists about 13 different crimes, and it considers those crimes. So the sexually dangerous predators, as Representative Saines has mentioned, make up some of the smallest group that SORB levels. It's 3% of everybody on the registry. This bill would give the judge two options when sentencing someone for those 13 crimes. Life in prison, that's on the table under this bill. Life in prison is on the table. But also, if the judge feels that that's excessive, they can give life probation after a mandatory 1 year of prison with the ankle monitoring. So life in prison could be eligible for some of these cases. There are already 200,000 people on probation in Georgia. This would add an additional 7% to the Department of Community Supervision's caseload without giving them any additional funds. And speaking of money, electronic monitoring fees amount to about $1,000 per year. And the last minute change that DCS asked for was that those fees not be incurred by DCS as they are today, they're incurred by the person on probation. So somebody with this level of crime, let's face it, is not going to get the best job. They're going to be struggling to make it. Now they're on the hook for over $1,000 a year. If they don't pay it, they're revoked. Their probation's revoked for the duration of the term, which is life. They're going to prison for the rest of their life for not paying their monitoring fee. Not to mention, they could be violated if they are out of cell service, if they're up in the mountains, if they go swimming and the monitor malfunctions. They could be revocated for that, which is life. So as we learned in the 90s, a war on crime is not effective. Back then, we're issuing life sentences after 3 strikes. This bill would go further and issue it after 2. Changing shall to may would allow a judge to fully evaluate the circumstances, including the risk classification. By the time someone commits a second offense, they could have a risk classification. So let's let the judge be a judge and see that get all the information, and if they feel that it's warranted for this person to spend the rest of their life in prison or on probation, so be it. I urge you to change shall to may and give judges a say.
All right, thank you very much.
Thank you.
That's all we had time to speak on this bill, and that'll conclude this hearing. We're adjourned.